Hello students, I hope you are doing well. So far we have discussed about various topics. We have talked about advantages, disadvantages of the company. We have discussed about the various kinds of the companies. There are 15 different types we have studied. We have also tried to understand the differences between the company and the other forms of entity. So today our topic is going to be we will proceed further, to the next stage about formation of the company. So what we are going to study? We are going to study about formation of company. Okay, so let's first try to understand, which are the three stages are there to form a company. So there are various stages in order to form a company. So let's try to understand first those stages. So first one is the promotion. Second one is the incorporation. And third one is the commencement of business. Commencement of business. So these are the three stages, in the incorporation of the company. So what is the incorporation of the company or the formation or registration of the company? So as per definition given under the Companies Act 2013, section 2 under subsection 20, company means a company which is formed and established or registered under this act, that is Companies Act 2013, or under any previous company law. So basically a company has to be registered. So person should come together, they should register a company. But who is the person who conceives that idea to go for that registration process? So first we'll try to understand about promotion stage. So what exactly happens in the promotion? So promotion, the role of the promoter will be very important. So promoter is the person who first conceives that idea. Promoter is the person who conceives that idea that yes, let's go for the incorporation of the company. So today my topic would be on this particular promotion part, and then in the next lecture we'll talk about incorporation. So let's talk about promotion. So before we'll try to understand about the role of the promoter, we need to understand the processes involved in the case of the promotion. So we can just jot down few points over here. So first of all, there has to be discovery of an idea. Discovery of an idea. Then we need to identify commercial feasibility of an idea. Then there will be the process of assembling. In assembling, everything will happen like arranging all the finances, properties and everything. Then deciding about the capital structure. The capital structure. So these are some of the few important steps you can say in the case of the promotion. So what is exactly mean by the promotion? So promotion is the first stage for the incorporation of the company. So it refers to the aggregate of the activities designed to bring that particular entity to operate a kind of business which is defined under the memorandum of association. So who is the person who is involved in the stage of the promotion? So as I told you, in the promotion, the very important person is promoter. Now let's try to understand who is the promoter and what is his role. So let me just put promoter. Students, in the old act, in 1956 Companies Act, the promoter definition was not defined anywhere in the act. But yes, that concept was already there. It was already very popular concept. But unfortunately, because that concept was not defined, okay, there was always a kind of ambiguity who can be called as a promoter. So that particular care has been taken while drafting the Companies Act 2013. So in case of Companies Act 2013, one specific provision has been given under definitions to define a promoter term. Now who is a promoter? Promoter is a person who conceives that idea that I should form a company. So whatever stages we have seen over here, discovery of an idea. So who discovers that particular idea? Okay, let's go for the company form of business. He tries to arrange everything, commercial feasibility. Okay, he checks whether that can be the feasible business to do. He tries to assemble various things and finally he decides what kind of capital structure has to be there. So promoter is a very important person in the company form of business. Promoter may or may not be the shareholder of the company. He may or may not be the director of the company, but his role is very important. He is a kind of caretaker, you can say. He is a kind of guide, mentor, you can say, for the formation of the company. And it is not that once the company is formed, his role will be over. There are various provisions in the Companies Act where the liabilities of the promoters are prescribed in case of various contraventions. So we will try to understand the role of promoter in detail, the provision given in the Companies Act in detail. So let's first try to understand who is the promoter. So as I told you, promoter is a person who conceives that idea of the company, and basically whatever the preliminary work has to be done by the promoter only. So the promoters are the person who decide the formation of the company. So who is the promoter? So if in the layman's language we need to understand, he is a person who decides formation of company. So पहला बात क्या है? Promoter is a person who decides formation of the company. Okay. So now the question will arise whether he is a kind of agent or trustee. No, he is not like. It is not like that. Promotion has a role to play. Promotion has a kind of fiduciary relation in case of the company. Okay. So we can say he stands. When I say he, okay, you have to understand that I am talking about promoter. He stands in a fiduciary relation in company. So he is a kind of fiduciary relation to follow. Promoter is a person who enters into various pre-incorporation contracts. I'm going to talk about that as well. He enters into pre-incorporation contracts. So he enters into pre-incorporation contract. Now what is meant by pre-incorporation contract? A contract which has been entered before incorporation of the company. Because there are various things to be done while incorporating a company. There might be some transactions, which should be executed properly. not in the name of the company, because company is not into existence till that particular time. So these are the contracts entered into by the promoter. I am going to talk about that little later. So most of the times he usually acts, not necessarily, he usually acts as first directors of the company. Not necessarily he should be the first director, okay, but in India we have seen so many companies where a promoter is the first director as well as he is a subscriber and the shareholder of the company. He should not make any secret profit. He should not make any secret profit. So if he is making any kind of secret profit, he has to account for it. So he has to give that account to the company. Okay, so basically this is the role of the promoter, you can say. This is the role of the promoter in India, okay, in layman's language. Of course, we are going to talk about the provision. That is the reason I am using the term layman's language. So, what are the functions of the promoter? Let's try to understand that. So, let's try to understand functions of promoter. Functions of promoter. So what is the first function? To conceive the idea of forming a company. So the first idea, okay, whoever conceives, he is a promoter. So to conduct, I would say to conduct necessary negotiation for development of business. If the question is asked, what is the promoter, which are the functions of the promoter, you should be in a position to write down such an answer. So conceive the idea means if the idea comes first time in the minds of the promoter, then he is the person who has to take it forward. So he conducts the various negotiations for the development of the business, which is going to be conducted in the name of that proposed company. I am using the word proposed company because so far there is no formation of the company. It is the promoters. It is still in the mind of the promoter. To arrange minimum subscribers and first directors. So as I told you, in India there are many private limited companies where the promoter is only the subscriber and he is only the first director, and this is totally allowed. There is no harm in doing that. So he may decide about the name of the company, okay, then he may decide about the registered office. I'm going to talk about that in the process of incorporation. Then capital structure, bankers, etc. There can be so many things, okay, he can do. So he is the person to arrange, you can say, MOA and AOA, to get MOA and AOA drafted and printed. Of course, the copies have to be kept. Okay, this copies should be submitted to the ROC. So this is the procedure. So from first to 4 point, he has developed that idea. He is ready with that idea. Now he is executing that idea, okay, into the formation of the company. So what he'll do, he will first arrange memorandum of association, articles of association of the company. To enter into pre-incorporation contracts. To enter into pre-incorporation contracts. So these contracts can be entered into with various vendors, various professionals, okay, who are involved in the formation of the company. So basically these are the preliminary expenses, you can say. These are the preliminary expenses promoter has to incur for the formation of the company, which can be in the form of pre-incorporation contracts. If it is a public limited company, to make arrangements for prospectus. Okay, if it is because public limited company requires prospectus to be issued. So in the prospectus also one can write down, okay, what should be who is the promoter, and all these promoter details should be mentioned in the prospectus. So these are basic important functions, you can say, okay, of the promoters. In the broader sense, to conceive that idea, to conduct the necessary negotiation for development of the business, to arrange minimum subscribers and first directors of the company. Name, register office, capital structure, he can only decide the bankers of the company. He can get it done, the memorandum of association and articles. These are the very important documents for the company form of business, and he can enter into pre-incorporation contract, and he can make the arrangements for prospectus as well. Now we'll proceed further and we'll try to understand the legal position of the promoter. So far we were discussing about, who is the promoter. It's in the layman's language, in the general language. What is the role of the promoter? What are the functions of the promoter? Now we'll talk about the legal position of the promoter. Legal position of promoter. Okay. So in order to understand this legal position of promoter, we need to understand section 2 subsection 69. Section 2 subsection 69, where the promoter is defined. So what is this section 2 subsection 69? Let's try to understand that. Now under in the erstwhile company law, that is 1956, the definition was not defined, as I told you earlier. So under section 2 subsection 69, it has been defined into three particular ways, in three particular points. So one by one we'll try to understand. I'm not going to write down the entire definition as it is. I would like to teach you this particular definition in a simple way, and that is the reason we'll try to put in the case of pointers. Let me just open the definition so that I can put it in the pointers. So we'll try to understand legal position of the promoter. So we can say a promoter is a person who fulfills any of the following conditions. So let's try to understand who is the promoter. Okay, so there are few conditions given under section 2 subsection 69. So the first condition is who has been named as the promoter in the prospectus. Who has been named as a promoter in a prospectus. So this is the first condition. Okay, I will put or because either of these conditions should be made. Who has been identified as a promoter in annual return. Who has been identified as a promoter in annual return. Okay, so annual return is basically filed by the company every year. So there is a prescribed format given under the Companies Act 2013, and when a company files this particular form, company has to put the name of the promoter. So whoever has been just named as the promoter, so he will be treated as a promoter. Who has control over the affairs of the company. Third condition, who has control over the affairs of the company. So this control he can maintain, directly or indirectly, as shareholder, maybe director, or otherwise. Okay, so let's try to understand this definition carefully. So these are the 3 points given over here. So what I have said, a promoter is a person who fulfills any of the following conditions. So any person who may fulfill either of these conditions will be treated as a promoter for a company. So the first condition is who has been named as a promoter in what? Prospectus. So this condition is applicable for a public limited company, because as we have studied earlier, a private limited company need not issue prospectus, because private limited company cannot go to the public and invite shares or securities. And that is the reason only public limited company has to issue the prospectus. And in case of public limited company, while issuing the prospectus, you may require the consent of the promoter because his name is incorporated in that prospectus. So whoever has been named in the prospectus later on cannot deny that I was not a promoter and I was not knowing the affairs of the company. So this is the first condition. The second condition is who has been identified as a promoter in the annual return. So as I told you, company has to file the annual return in a year, and in that annual return there are various things to be incorporated. So like the various informations have to be provided by the company during that year, whether there was any kind of change in the shareholding, or you can say the director's appointment, So all these particular details should be incorporated in the annual return. And there is one more clause for the promoter. So whoever has been identified as a promoter by the company itself, you can call that person as the promoter. Who has control over the affairs of the company? Who has control over the affairs of the company? Now this is a little tricky concept to understand. Directly or indirectly, either as a shareholder, director or otherwise. So as I told you earlier, promoter may become a shareholder. Promoter can also become the director of the company. Not necessarily that okay, he should only promote the company and that shareholder or the director task can be given to other persons. It is not like that. So either he may hold directly the shares of the company or he may indirectly hold the shares through his relatives. Then also he may be called as promoter. So by controlling the overall affairs of the company, what is meant by control? Control means the majority of the decision making powers are in the hands of the promoter. Either it may be in the direct way or indirect way. So in that case also that person should be identified as a promoter. Or otherwise. Now this is a question mark. What is meant by otherwise? Otherwise can be anything. It should not be like okay, he is just the shareholder or director, then only okay he will be called as promoter. Otherwise also, if okay the company board of directors of the company okay while taking the decision ask him okay about that particular person, means without taking the view of that person the decisions are not taken. So we can add one more point over here. In accordance with whose advice you can say directions or instructions BOD is accustomed to act. BOD is accustomed to act. So what does it mean? Means without taking his consent, BOD is not able to take decision. Now whoever that person may be. So see, without taking consent of a person, BOD is not able to take decision. It's very gray area to find out. But BOD will not just give such kind of power to anyone. Okay, he must be so powerful person that his decision is so important. And that is the reason whose advice, direction or instruction BOD is taking from the time to time. Okay, and then accordingly the decisions are being taken. Then that person will be called as promoter. Now here the question will arise. Whether an advocate, whether a company secretary or the chartered accountant and cost accountant for that matter, these are all professionals, okay, they will all deal with the company form of business from time to time. Now board of directors of the company are taking advices from these persons from time to time while taking the decisions, because most of the decisions are taken during the board meeting. Now when a board of director is asking some type of advice and these professionals are providing the advice, so whether they will fall under the definition of promoter. So this is a question. So that is the reason there is some kind of proviso mentioned, okay, in this Companies Act. Okay, so we can say whoever acting in capacity of in a professional capacity and giving advice will not be considered as promoter. So I can just say, I can just add one more point just for your understanding. So you can say this is a kind of exception to the rule of promoter. Exception to rule of promoter. So what is that? Whoever giving advice to BOD in professional capacity will not be considered as promoter. Will not be considered as promoter. So whoever is giving advice to the BOD in professional capacity. So for example, you can say, I have given you some examples like professionals like advocate, you can say, or CAs, CS, CMA, okay, all these, or any other person as well, okay, not necessarily these are the, because law has not defined who can be the professional, okay. So whoever, you need to understand that whoever will give, okay, advice in the professional capacity should not be treated as promoter. Otherwise it will be really very difficult for professional to give such kind of advices to the board of directors from time to time. So we have talked about the promoter as defined under this particular provision, okay, section 2 subsection 69. Let's proceed further and try to understand the duties of promoter. Now this question can be expected in the exam. Duties of, so now we'll talk about duties and liabilities of the promoter, okay, given under the Companies Act. So first duty is to disclose all material facts. To disclose all material facts. See, the duties and the liabilities are not prescribed in one particular section. These are all scattered provisions given under the Companies Act. Not to make any secret profit, not to make any secret profit, to disclose interest in the transaction, to disclose the interest in the transaction. Not to make unfair use of his position. So he should not make the unfair use of his position. And not to accept appointment as independent director. Okay, so these are some of the duties, you can say, okay, of the promoter, and to attend before the tribunal whenever required, to appear, or you can say to attend tribunal proceedings, so whenever required. Okay, this is not always, okay, if required. So I will just put the word if required. So these are some of the duties of the promoter. So when he has to make the disclosure of all material facts which will affect, okay, the business, but by which the business of the company is going to be affected. So all those material facts which are in the knowledge of the promoter should be disclosed properly. He should not make any kind of secret profit. Now, what is secret profits is not defined. So, by using the name of the company, he is earning kind of secret profits. Then he has to account for it. He has to show it to the company and he has to give it back to the company. Not to disclose interest, to disclose the interest in the transaction. See, there is a concept called as related party transaction. So basically, such kind of transaction, the interest has to be disclosed. So as I told you, most probably the promoter can be the director of the company, and there are provisions in the Companies Act. From time to time they have to disclose their interest in one particular transaction, and there can wherever. What is a transaction? Like if I am the promoter of the company and I am selling my property to the company, then I will become the interested party in that transaction. So I will have to disclose that the property belongs to me. So that is the disclosure of the interest in the transaction. Not to make unfair use of his position, because he is in the fiduciary relationship. We have already discussed. So when we say that he is in a fiduciary relationship, he is a kind of guide or caretaker for a company. And that is the reason he should not make unfair use of his position. Not to accept appointment as independent director. So this is one of the disability for the appointment of independent director. Independent director definition and the provisions are given. Provisions are given under 149 section. So a promoter and other parties also, there are there are various provisions given for the independent director. So person falls under that particular category, then he is not eligible to become the independent director. So in case of promoter also, promoter being the interested party, he should not be appointed as the independent director, because the independence will not be, will be defeated. So the independent director is basically a caretaker for the mind, or you can say public money. To attend tribunal proceeding, so whenever the tribunal will ask, tribunal here means NCLT or NCLAT, so he will have to attend the tribunal proceedings whenever the case related to the company will be entertained or will be there on the board before this tribunals. So these are some of the very important duties of the promoter. Let's talk about the liabilities of the promoter. Liabilities of the promoter. Liabilities of promoter. As I told you, liabilities are the scattered provisions given under the Companies Act 2013. So there is no particular section which is talking about one liability, all these liabilities. So the liabilities are scattered and defined in the various ways. So whenever the penalty party will come and the person is a promoter, the promoter may be held liable. So try to understand why this concept of promoter has been incorporated in 2013, with the view that a person should not just start a business of the company and then he will run away and in the name of the company the frauds will be committed. With the help of the various examples, we have seen so many frauds in the name of the company. So such type of fraud should not be committed against, and that is the reason we require this definition of promoter. So liabilities. First liability we can say for furnishing false information. False information for incorporation. So while going for the incorporation, if is deliberately providing a kind of false information, then there is a concept called as liability for misstatement in prospectus. So he may be liable for any kind of misstatement in the prospectus. Liability liability for contravention of provisions related to private placement. So private placement is defined under section, these provisions are given under section 42. Liability for failure to repay money. So when there is a misstatement in the prospectus and the repayment or application money has to be refunded in some cases and is not refunding back the money, because see, when the application money is given and after that, okay, once the allotment is done, securities have to be issued. So there are some prescribed timelines given, and if it's not doing so, then the application money has to be refunded, and if he's not going to give, then he will be liable. And liability for preliminary contracts. Liability, you can say, one more liability we can put, liability for not disclosing, liability for not disclosing material facts. So if he is not disclosing the material facts, then he will be held liable. And liability for pre-incorporation contracts or preliminary contracts. Liability for pre-incorporation contracts. Okay. So all these are the liabilities which are scattered, okay, in various sections of the Companies Act 2013. So if is providing the false information for incorporation to the ROC, because he is the person who will go to the ROC and okay for the formation of the company. If is providing the misstatement in the prospectus, see, misstatement in the prospectus is one of the very so you can say there is a heavy penalty level for the misstatement in prospectus, because on the basis of the prospectus the proposed investors of the company are going to invest money, and if you are making some false statement or misstatement for that matter, then the money invested by the shareholders will be wasted. Okay, so they will be at loss, and that is the reason promoter will be held liable to repay that money. So there can be civil liability, criminal liability given under the misstatement provisions. Contravention of the provisions relating to private placement, section 42 talks about the private placement. This is a concept where the private placement, the shares can be privately placed. So not necessarily there are some provisions where the company wants to privately place some securities to certain persons. To the certain persons the limit is maximum 200. But you must be aware about the Sahara group case. Okay, Subrata Rai of Sahara was arrested for certain matter, and after that this provision has come into picture. So promoter should be held liable if a company is contravening the provisions relating to the private placement. Whenever the topic will come, we'll talk in detail about the private placement. Liability for failure to repay money. Okay, repay application money also you can say. As I told you, if the securities are not allotted properly or not shares are not issued within the timeline, then the application money has to be refunded to the shareholders, and that is the role of the promoter. Liability for not disclosing material facts. In the duty of the promoter we have seen the disclosing the material fact is one of the core duty of the promoter, and if he is not doing so, if he is not fulfilling that particular duty, then he will be held liable for not disclosing the material facts. Liability for pre-incorporation of contracts. So what is pre-incorporation contract? We are going to talk about that. Pre-incorporation contract, whatever the liability will occur, it will occur, okay, on the promoter only, because the company has not come into existence so far. So here we have completed the topic of promoter. Now we are going to talk about the second topic for this today's session, that is pre-incorporation contract. Before that, okay, if you want to just write down all the points, please mention these points. So we have started with formation of the company. So promotion, that is the topic we are doing. Then which are the steps, important steps for the promotion? Discovery of an idea. The first step, you have to have that idea in mind and okay, which type of company you are going to incorporate. Then commercial feasibility, you need to identify for that particular idea whether it will be really commercial in nature. Assembling in the sense you have to just assemble various resources to complete that particular idea, and deciding about the capital structure, what type of capital structure you are going to introduce in your company. The role of the promoter in layman's language, he is the person who decides formation of the company. He stands in the fiduciary relation. So I can just underline the important part. Decides formation, fiduciary relation, enters into pre-incorporation contract, the topic which we are going to talk about. Usually acts as the first directors and not to make any secret profit. That is the main important role of the promoter. Let's write it down. Then we have discussed about the functions of the promoter. Question can be expected in the exam. So what are the functions of the promoter? To conceive that idea for formation of the company, to conduct necessary negotiation, to arrange minimum subscribers and first directors, then to arrange various things to get MOA drafted and printed, enter into pre-incorporation contract, that is the one of the role and its function also. Arrangement for the prospectus if it is a public limited company. Just write it down. Then we have discussed about the legal position of the promoter given under section 2, subsection 69 of the Indian Companies Act 2013. So promoter may be any person who will fulfill any of these criteria. So this is a very important section. Question can be expected for 2 marks. Definition of the promoter. The short note question can also be expected, okay, in your exam. Then we discuss about the exception part. So in exception, we have seen whoever is giving advice to the board of directors in professional capacity will not be considered as a promoter. I have given you examples like advocate CACS who are acting in the professional capacity and giving advices to the board of directors from time to time. They should not be considered as a promoter. Otherwise, it will be very difficult for this professional to act. In duties of promoter, just make a note of all these points. Write down the liabilities of the promoter. So liabilities, as I told you, are scattered provisions contained in the various sections of the Companies Act 2013. So for furnishing false information for incorporation, misstatement in prospectus, private placement, contravention of provisions, repayment failure, disclosing material facts is not done, and pre-incorporation contracts. Okay, I hope you have written all these points. Okay, these pointers will really help you out during your exam. Now let's quickly talk about, before we'll conclude with this session, let's quickly talk about pre-incorporation. So pre-incorporation, or that may be also called as preliminary contracts. Pre-incorporation or preliminary contracts. Okay, so what is meant by pre-incorporation or preliminary contracts? First, let's try to understand the definition. So there is no prescribed definition as such given under the Indian Companies Act 2013. But what can be pre-incorporation contract? The contracts which are entered into by the promoters before incorporation of the company. Okay, so this can be the definition for the pre-incorporation contract. So if a question is asked for the pre-incorporation contract or preliminary contract for 2 marks, you should say that the contracts which are entered into by the promoters before incorporation of the company are called as pre-incorporation contracts. Now, why do we need to study? Okay, why we should study these pre-incorporation contracts? Because for pre-incorporation contracts, who should be held liable? So, like contracts, okay, the promoter has entered into, let's say, with the vendors or with any kind of professional who is involved in the formation of the company, and he has decided through that contract that I will pay you certain amount of, let's say, 15,000 or 20,000 rupees for the formation of the company, but only after formation. Now, if he is not able to pay, whether the company will be held liable? So now question will arise whether company can be held liable for pre-incorporation contracts. Okay, so let's try to understand this. So what do you think, whether company can be held liable for the pre-incorporation contracts? Prima facie, company cannot be held liable because these are the contracts. Try to understand, these are the contracts promoters have entered into before incorporation. It means before the company has even come into existence. And that is the case. How come company can be directly held liable for the pre-incorporation contracts? So at the first instance, company may not be held liable for the pre-incorporation contracts. Then who are the persons who are liable for the pre-incorporation contract? So promoter can be held liable. Promoter is liable for pre-incorporation contracts. So always remember, because the company is not in existence, okay, the company's liability will not be there. But does it mean that company will never be liable for these pre-incorporation contracts? So when the company, now my first question was whether company will be liable or not. So the question to this particular answer, prima facie at the first instance, company is not liable. So who is liable? Promoter is the person who is liable because he himself has done that particular contract. So if a company enters into any contract before its existence, then how come that company can be held liable? But in a situation where after incorporation, if company adopts that particular transaction in its board meeting, then yes, company can be held liable. So now my question, the second question can be, when company can be held liable? When company can be held liable for pre-incorporation contracts. So answer to this particular question, you can say, if company adopts pre-incorporation contracts after its incorporation, then company can be held liable. Company can be held liable. Okay, so to answer this to this particular question, you can say, if the pre-incorporation contract has been entered into by the promoter, which will be adopted. Now that is not mandatory for a company to adopt the pre-incorporation contract, but if a person, okay, in most of the cases it happens that, okay, in most of the cases the company after its incorporation during the first board meeting only adopts the pre-incorporation contract, and in that particular case, okay, after adoption the company's liability will be there. So please note it down, this definition and the questions which may be raised for the pre-incorporation contracts. I would like to quote one case law over here for your kind information, Kelner versus Baxter. Kelner versus Baxter, 1866. This is a very old case law. Kelner versus Baxter. Okay, 1886. This is a very old case law. In this case law, the court has held that in this particular case law, could not ratify the contract before its incorporation, and it is not the liability of the company. Okay. So in this particular case law, there was a question of specific performance. So any particular contract which has been entered into by the promoter before its incorporation, whether the liability will come on the company or not. So after understanding these two particular questions, one can say that no, the liability will not come, because before the incorporation, the liability or the onus will be on promoter. Now, in this particular case law, there was a question of specific performance of a contract entered into by the promoter. So, court held that before its incorporation, company is not in a position to ratify the transaction, and that is the reason the question of specific performance will not also arise. So, this is a case law you can quote while giving the answer for the pre-incorporation contract. I hope you have understood this particular topic very clearly. Okay, please note it down all these points as well. So students, here we have come to an end of this particular session. So today we have understood about promoter, its liability, its various functions, promoter's functions. Then we have talked about the pre-incorporation contract provisions. Okay, and the very important section, that is section number 2, subsection 69, which defines promoter. So thank you so much for attending this session, and do watch this video, read the notes. Thank you so much. Bye bye.